Assalamualaikum warahmatullahi wabarakatuh. My name is Qurratu Ayyun Binti Zolkifli. So I will be presenting the first issue, which is whether the exercise of security powers is constitutional. The first sub-issue is whether the declaration of the entire country as a security area under the National Security Council Act 2016 is constitutional and consistent with Article 150 of the Federal Constitution. Firstly, it is important to understand the legal framework governing security declarations in Malaysia. Under Section 18 of the National Security Council Act, the Prime Minister may advise the Yang di-Pertuan Agong to declare any area in Malaysia as a security area if the security of that area is seriously threatened. The purpose of this provision is to allow the government to respond effectively to genuine threats to national security. Article 150, Clause 1 of the Federal Constitution provides that Yang di-Pertuan Agong may proclaim an emergency if he is satisfied that a grave emergency exists whereby the security, public order, and also economic life of the Federation is threatened. So, the constitutional power to proclaim an emergency lies with Yang di-Pertuan Agong, while the Prime Minister's role is limited to advising him. The constitutionality of the National Security Council Act was challenged in Datuk Seri Anwar Ibrahim against Kerajaan Malaysia and another. The plaintiff argued that the act should have been enacted under the Article 149 because it concerns security matters and affects fundamental liberties. However, the Federal Court upheld the validity of the National Security Council Act and held that Parliament was not required to enact the law under Article 149. The court also recognised that restrictions imposed under the Act could be justified on security grounds. However, the present scenario can be distinguished from the Anwar Ibrahim case. Although the National Security Council Act itself is constitutional, the power granted under the Act must still be exercised lawfully, reasonably, and for the purpose intended by the Parliament. In this case, Guru allegedly misused his power by declaring a nationwide security area after public awareness of his corruption increased in social media and his political position became threatened. This situation does not amount to a serious threat to national security, public order, or the economic life of the country, as required under Article 150. Instead, the declaration appears to have been made to suppress public opposition and prevent a rally against his government. So, Guru's action can be regarded as malafide because he exercised the power for an improper purpose. His actions were also unreasonable and disproportionate since a nationwide security declaration is an extraordinary measure intended only for a genuine security threat. To conclude, Guru's declaration of a nationwide security area is unconstitutional because it was made for his personal political interest rather than for national security. Furthermore, the power to proclaim an emergency belongs to Yang di-Pertuan Agong under the Federal Constitution and not to the Prime Minister acting alone.
Assalamualaikum warahmatullahi wabarakatuh. I am Nur Aathiqah binti Ajmal Ibrahim with my metric number 2418982. I will be presenting on the second sub-issue, which is regarding whether the nationwide curfew imposed by Guru unlawfully infringes the constitutional right to freedom of movement under Article 9 of the Federal Constitution. Article 9 Clause 2 guarantees that every citizen has the right to move freely throughout Malaysia and to reside anywhere in the Federation. However, this right is not absolute. It can be restricted by laws relating to public order, security, public health, and the punishment of offenders. This means that although freedom of movement is a fundamental right, it is a qualified right and can be limited if the restriction is made under a valid legal authority and for legitimate constitutional purposes. In the case of Asal Singh against Menteri Besar Johor 1969, the court recognized that laws restricting movement can be valid under Article 9 Clause 2 if they are made for security or public order reasons. However, the court also made it clear that such restrictions must comply with the Constitution as a whole, especially Article 5, which protects personal liberty and guards against arbitrary state action. So even if the restrictions are allowed, they cannot be arbitrary or excessive. Similarly, in Government of Malaysia against Loh Wei Kong 1979, the court confirmed that constitutional rights are not unlimited. Any restriction must be justified within the constitutional framework, and the government cannot exercise unfettered discretion when limiting rights. Applying these principles to the present case, Guru has imposed a nationwide curfew after declaring the whole country a security area under the National Security Council Act 2016. This clearly restricts the citizen freedom of movement under Article 9 Clause 2 since people are no longer free to travel or move within the nation. Although the government may argue that the curfew is based on national security and public order, the facts suggest that it was imposed following public criticism of alleged corruption and to prevent a peaceful rally supporting Gaga. The rally itself was meant to be peaceful and did not indicate any real threat to national security. Therefore, while Article 9, Clause 2 does allow restrictions, those restrictions must be lawful, necessary, and not arbitrary. Based on these facts, the curfew appears to be disproportionate and politically motivated rather than a genuine security measure. For these reasons, it is most likely that the nationwide curfew is unconstitutional as it violates Article 9, Clause 2 of the Federal Constitution.
The first sub-issue is whether the prohibition of the planned rally unlawfully infringes the constitutional right to freedom of assembly under Article 10, Clause 1, Clause B. According to PP and Ismail, assembly is defined as the coming together of two persons or things, a gathering of persons. Assembly is wider than a meeting and includes any coming together of persons. So, according to Article 10, Clause 1b, all citizens have the right to assemble peacefully and without arms. This right is not absolute. Pursuant to Article 10, Clause 2b, Parliament may impose restrictions on this right as it deems necessary or expedient in the interest of the security of the Federation or public order. Moving on to the Peaceful Assembly Act, Section 4 recognizes the right to peaceful assembly, while Section 9(1) states that we need to inform regarding the assembly that we want to make 5 days before the date to the police officer. And Section 9, Clause 4 of the same Act, Clause 4 of the same Section 9, it states that the notification must be given by post or courier or by hand. There are three cases that I would like to explain. So first, using the case of Nick Nazmi. So in this case, it says that restrictions are allowed and total prohibitions are not allowed. While in the case of Amir Hariri, restrictions must satisfy the proportionality and less restrictive measures are preferred to be used. While in the case of, to distinguish these two cases with Yunus Warren, it concerned a failure to give notice in this case. So it did not involve a complete ban on assembly. Applying the law to the facts, the proposed rally falls within the protection of Article 10 Clause 1b because it was intended to be a peaceful assembly in support of Gaga. There is no evidence that the participants intended to engage in violence, unlawful conduct, or threaten public order. So applying Nazmi, the court held that Article 10 Clause 2b allows restriction but no total prohibitions. In the present case, the nationwide curfew completely prevented the rally from taking place. Therefore, the restriction resembles a prohibition rather than a mere regulation of assembly. Next, applying Amir Hariri, any restriction on peaceful assembly must satisfy the principle of proportionality. Here, the authorities could have adopted less restrictive measures, such as requiring prior notice, imposing reasonable conditions, or deploying police officers to maintain public order. Instead, Guru declared the entire country a security area and imposed a nationwide curfew. This response is clearly excessive compared to the alleged threat. The government may also rely on Yunus Warren and PP. However, that case is distinguishable compared to the other two cases because it only concerned the failure to comply with the notice requirement under PAA. In contrast, in the present case, it involves a blanket nationwide curfew that prevented the rally from taking place altogether. Therefore, the case of Yunus Warren does not justify Guru's actions. Furthermore, the curfew was imposed shortly after public criticism against Guru intensified. So this suggests that the measure was aimed at suppressing political oppositions rather than addressing a genuine security threat. So in conclusion, the nationwide curfew was disproportionate, effectively prohibited peaceful assembly, and likely violated Article 10 Clause 1b of the Federal Constitution. So that's all from me. Thank you.
So the second sub-issue is whether the freezing and takedown of Gaga's and Gigi's social media accounts unlawfully infringe their right to freedom of speech and expression under Article 10(1)(a) of the Federal Constitution. So Article 10(1)(a) protects the freedom of speech and expression for all citizens, including companies. So speech here includes spoken words, expression includes writing, art, media, and creative forms. So there is a limitation in Article 10(2)(a), which is for national security, public order, morality, defamation, incitement, parliamentary privilege, or contempt of court. But this restriction must be reasonable and proportionate. As established in PP and UKISAIK, speech may be limited to prevent stability and protect public order. And furthermore, in the case of Utusan Melayu and Datuk Sri Diraja Haji Adnan bin Haji Yaakob, press freedom is protected but subject to clear legal limits. In another case of Muhammad Hilman bin Idam and Kerajaan Malaysia, restriction must have a real link to public order or morality. Furthermore, there's a limitation in Article 10(4), which Articles 149 150 allow special laws on sensitive issues and national security, including Sedition Act 1948. So Sedition Act 1948 is prohibits speech that incites hatred, contempt, disaffection, hostility, or unlawful charge. The freezing and removal of Gaga's and Gigi's social media accounts restricted their freedom of speech and expression under Article 10(1)(a). So their posts constituted
political expression as they criticized alleged government wrongdoing and sought to clarify public statements. Although there's a limitation in Article 10(2)(a), but the restrictions must be reasonable and proportionate. There's no clear evidence that their statements amounted to incitement or pose an immediate threat to the public order. As recognized in the cases of PP and UKI and Utusan Melayu, legitimate political criticism should not be suppressed under Article 10. The application of Sedition Act 1948 is also doubtful, as the statements appear to be more as a political criticism rather than a speech with a seditious tendency. Therefore, the restriction was likely unjustified, disproportionate, and unconstitutional.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nur AQILAH FAQIHAH Binti ARIFA, metric number 2416486. Now, I will be presenting about the third issue, which is whether the sedition charges against Gaga and Gigi are lawful and constitutional. So, to determine the validity of the sedition charges, we need to take a look to Article 10, Clause 1, Clause A, where the Federal Constitution gives the right to freedom of speech and expression. But this right is totally not absolute, as under Article 10, Clause 2, Clause A, it gives Parliament the power to impose restrictions that are necessary in the interest of morality, national security, or public order. As we can see in the case of PP against Azmi Sharom, it stated that federal court eventually they examined the constitutional position of the Sedition Act 1948, where the court held that the Sedition Act is valid as it is a pre-Merdeka law, which is saved by the Article 162 of the FC, and it constitutes a permitted restriction under Article 10, Clause 2, Clause A. So, in the Sedition Act 1948, of Section 3, Clause 1, Clause A, it defines the term of seditious tendency, which means as to bring into hatred or contempt or to excite dissatisfaction against any ruler or against any government, which they have an amendment in 2015, but it's actually called as a zombie amendment, as it does not give any effect till now. And however, there is an exception based on Section 3, Clause 2, Clause B of the same Act that states an act, speech, or publication is not deemed seditious if it's made solely to point out errors or defects in the government or constitution. So, with a view to the remedying of such errors or defects, thus in the case of PP against UKI, it established that under Section 3, Clause 3, the subjective intention of the speaker is not important, but the words objectively have a seditious tendency. However, if an individual just try to criticize personal financial misconduct, graft, and nepotism of a prime minister, it does not equal to the disaffection or hatred against the government, as how the law established. This is because the criticisms did not apply to race, religion, and royalty, which is the 3R, and it was restricted under Article 10, Clause 4, where no objective seditious tendency can be found. All the law to the situation of Gaga and Gigi, to say that the Sedition Act is unconstitutional is not correct or right, as based in the case of PP against Sharom, as it is stated that the Sedition Act is constitutional. Therefore, Gaga and Gigi cannot challenge the constitutionality of the Sedition Act as a whole. This is because the statute, it remains binding and valid under the Malaysian law based on Article 162. Even though the Act is constitutional, the law that was imposed on Gaga and Gigi is not relevant and factually groundless, because as based on the definition in Section 3, Clause 1, Clause A, it states that any acts that brings hatred or contemppt or excites the dissatisfaction against any ruler or against any government is seditious tendency. But there is an exception in Section 3, Clause 2, Clause B, where Gaga, he only reached out to Guru because he wanted to advise him that his overall acts is immoral, and it has cronyism, which his intention was only aimed at correcting administrative wrong. Gigi's post on social media explicitly stated that Gaga only wants to give honest and constructive feedback, and their actions were within the protection of Section 3, Clause 2, Clause B, as the intention was to rectify the corruption and misappropriation by a public official. Also, we can distinguish the case with PP against Okisai, where he only criticizing the misconduct of Guru as a prime minister, which could harm the nation. Also, their criticism does not touch upon sensitive pillars of race, religion, and royalty. So in short, the Sedition Act remains constitutional valid under the current precedents, but the application of the law to Gaga and Gigi is unlawful, as Gaga private and moral advice to Guru and Gigi's post in the social media clarifying that it was a constructive feedback which falls in the protection of Section 3, Clause 2, Clause B. So, now we move on to the fourth issue, which is whether the arrest and prosecution amount to constitutional violation or abuse of power. So, the first sub-issue is whether the arrest and prosecution based on Article 5, Clause 1 of the Constitution, it stated that no person shall be deprived of his life or personal liberty save in accordance with law. Personal liberty can be defined as right relating to the body of a person, i.e. nobody can touch or hurt you. In a Malaysian case of Government of Malaysia against Law Kong, a person wants to claim that he has the right to a passport as he wants to travel abroad. He states that by depriving him of his passport, The government also deprived him from the right to personal liberty. However, the court rejected this argument because the court stated that personal liberty is a personal right not to be subjected to imprisonment, arrest, or physical coercion in any manner that does not admit legal justification. Personal liberty relating to the person or the body of the individual, which does not include the right to travel overseas or to have a passport. In another case, which is called as Sugumar Balakrishnan, it is a landmark case that establishes state immigration authorities can cancel entry permits and bar individuals without providing reasons or a right to be heard. The court interpreted personal liberty under Article 5, Clause 1 of the Federal Constitution narrowly in this case. It determined this right cannot be construed in excessively broad terms to defeat explicit statutory immigration controlled by the state. Applying the rules to this situation, Gaga and Gigi were arrested and detained by the authorities. Unlike Lowaikong and Sugumar Balakrishnan, which involves attempts to give a broader meaning to personal liberty, the prison case involves actual physical restraint through arrest. Therefore, this situation falls within the protection of Article 5 Clause 1. Although the arrests were met under the Sedition Act, Gaga and Gigi may argue that the prosecution was motivated by gross intention to silence criticism and punish them for exercising their constitutional rights. If the arrests were met for an improper purpose and not in accordance with the law, they will be unconstitutional. In conclusion, Gaga and Gigi have grounds to argue that their arrest violated Article 5 Clause 1 of the Federal Constitution. Since they were subjected to actual detention, their right to personal liberty was affected. If the arrests were politically motivated and amounted to selective prosecution, they would not be considered a deprivation of liberty in accordance with law and would therefore be unconstitutional.
The second sub-issue is whether the criminal prosecution against Gaga and Gigi constitute mala fide selective prosecution or an abuse of executive power. Article 5, Clause 1 of the Federal Constitution states that no person shall be deprived of personal liberty except in accordance with law. This provision protects individuals from unlawful arrest and detention and ensures that law enforcement authorities act within legal limits. An arrest is only lawful when there is an objective and reasonable suspicion that a crime has been committed. This principle was affirmed in Shaban and others against Chong Fu Kam and another. In this case, the police arrested and detained the plaintiff because their lorry matched the description of a vehicle involved in a hit-and-run accident. However, there was insufficient evidence linking them to the offence. The private counsel held that the police lacked reasonable grounds for suspicion, making the detention unlawful and amounting to false imprisonment. Another important case is Muhammad Izam bin Muhammad Noor against Ketua Polis Negara. Although the authorities claimed that the detention was necessary for national security, the court found that it was carried out for an ulterior purpose that is unrelated to national security. This amounted to mala fide, which means that an action taken in bad faith or for improper motive.
I am your Aathiqah Binti Ajmal Ibrahim 2418982, and I will be presenting on the application and conclusion of the second sub-issue of issue number 4. In the present case, the criminal prosecution against Gaga and Gigi appears to constitute mala fide, selective prosecution, and an abuse of executive power. The prosecution was initiated shortly after Gaga privately criticized Guru's alleged corrupt practices, and Gigi, who publicly defended Gaga while proposing a peaceful rally in support of him. Importantly, there is no evidence that either Gaga or Gigi advocated violence or any attempt to overthrow the government. In the case of Muhammad Izam Muhammad Noor against Ketua Polis Negara, the court made it clear that the exercise of public power for an improper or ulterior purpose is unlawful. Applying that principle here, the circumstances suggest the prosecution may have been used not to uphold national security, but rather to silence the criticism and suppress political opposition against Guru's administration. Furthermore, under Article 5, Clause 1 of the Federal Constitution, and as affirmed in Shaban and others, any arrest or prosecution must be supported by objective and reasonable grounds. In this case, there appears to be insufficient factual basis to justify the sedition-related charges, especially given the peaceful nature of the intended rally and lack of evidence of violence or threat conducted. Therefore, Gaga and Gigi may argue that the prosecution is mala fide and amounts to an abuse of executive power, as it appears to be motivated by a desire to suppress criticism rather than a genuine concern for national security. As a result, the arrest and prosecution may be argued to be unconstitutional and in breach of Article 5, Clause 1 of the Federal Constitution. That's all from me. Thank you.